Something remarkable is happening in America, something that's quietly reshaping the national conversation about our rights and freedoms. It's a story you won't hear on the nightly news or see splashed across the front page of your morning paper. The very people who have spent years fighting to disarm law-abiding citizens are now, through their own relentless efforts, making the most compelling case for the Second Amendment that we've seen in decades. Their legal crusades against so-called large capacity magazines are backfiring spectacularly, exposing a simple truth. These magazines are not just common, they're protected by the Constitution itself. For years, activists and politicians chipped away at the Second Amendment, using loaded language and fear to label ordinary magazines as dangerous, all to justify sweeping bans. But they overlooked a fundamental fact. The Second Amendment isn't about hunting or sport shooting, it's about the right to self-defense and the ability of Americans to protect themselves and their loved ones. Now, their extreme bans are forcing courts across the country to confront a critical question. Where does government power over firearms truly end? And where do individual rights begin? In their zeal to restrict, they've unwittingly become the star witnesses for the defense of our rights, providing evidence and arguments that strengthen the very freedoms they sought to limit. We'll walk through the heated legal battles unfolding in Oregon, the political theater playing out in Minnesota, and the passionate debates that are shaping the future of gun rights in America. And we'll witness the high-stakes showdown in California, where the outcome could set the tone for the entire nation. You'll see how time and again, their arguments have backfired, creating powerful legal precedent that strengthens, not weakens, the right to keep and bear arms for all Americans. This is the story of how the enemies of freedom, through their own actions and unintended consequences, accidentally became its unlikely champions, reminding us all that the fight for liberty is never truly over. Before we dive in, let's clarify what's at stake. The conversation around so-called large-capacity magazines is filled with confusion, and that's not by accident. Understanding the real facts is crucial, because this debate affects millions of responsible Americans. The term large-capacity magazine is a deliberate deception. These are actually standard-capacity magazines, sold with the most popular firearms in America. For decades, these magazines have come as the default option, not some rare or extreme accessory. Millions of law-abiding Americans own magazines holding more than 10 rounds. It's the norm, not the exception. In fact, for many common firearms, magazines that hold 15, 17, or even 30 rounds are standard equipment, not an upgrade. Calling them large capacity is like calling a sedan a large capacity vehicle, because it holds more than a motorcycle. It's a misleading comparison designed to make something ordinary sound extreme or dangerous. These magazines are essential for effective self-defense. Police carry them for the same reason. When seconds count, having enough rounds can mean the difference between life and death, whether you're a law enforcement officer or a civilian protecting your family. The gun control lobby wants you to believe you deserve less protection than government agents. They argue that ordinary citizens should be limited, while officials remain fully equipped. When politicians rail against high-capacity magazines, they're targeting what you already own. They're not just talking about rare or exotic gear, they're talking about the magazines that come standard with your firearm, the same ones you rely on for safety. Their goal isn't safety, it's to make you more vulnerable by limiting your ability to defend yourself. Restricting magazine capacity doesn't stop criminals, but it does put law-abiding people at a disadvantage when it matters most. The entire debate is built on this fundamental lie, and it's finally being exposed. The truth is that these so-called large-capacity magazines are simply what most Americans use every day. Don't be fooled, they're not talking about military hardware, but the magazines you and your neighbors use every day. These are the tools of responsible citizens, not criminals or extremists. The truth is out, and the narrative is crumbling. It's time to see through the rhetoric and recognize what's really at stake: your right to effective self-defense and the facts behind the labels. Nowhere is the anti-gun movement's self-sabotage clearer than in Oregon. In 2022, activists passed Measure 114, banning standard-capacity magazines and creating a convoluted permit system. Instead of a victory, they sparked a legal disaster. The Supreme Court's Bruin decision forced them to prove their ban fits America's historical tradition, a test they can't pass. There's no history of banning magazines by capacity. Firearms have always evolved toward greater efficiency. Oregon's law was struck down, then appealed, and now heads to the state Supreme Court, with the U.S. Supreme Court looming. By pushing such an extreme measure, they've created a test case likely to affirm that standard capacity magazines are protected arms. Their ambition has set the stage for their own defeat. Oregon's overreach may become the precedent that ends these bans nationwide. California has long been the epicenter of aggressive gun control in America, and now, its controversial magazine ban is starting to unravel under legal scrutiny. The state's lawmakers have pushed the boundaries of what's constitutionally acceptable, sparking a fierce debate that's drawing national attention. California argues that magazines aren't arms protected by the Second Amendment, a legal position so weak it exposes the ban's fundamental absurdity. Critics say this argument ignores both the letter and the spirit of the Constitution and undermines the rights of law-abiding citizens. After all, a firearm without a magazine is like a printing press without ink, rendered useless for its intended purpose. Magazines are essential components, not accessories, and millions of Americans rely on them for self-defense and sport. Even the liberal Ninth Circuit Court initially struck down the ban, recognizing that these magazines are in common use for lawful purposes and that banning them infringes on fundamental rights. Now the case has reached the U.S. Supreme Court, where the outcome could have sweeping, nationwide implications for gun owners and state laws across the country. California's refusal to back down, despite repeated legal setbacks, has forced the highest court in the land to confront the issue head-on, setting the stage for a landmark decision. By defending a law that many see as indefensible, California has created the perfect opportunity for the Supreme Court to reaffirm and clarify the right to own standard magazines for all Americans. This overreach is likely to backfire, setting a powerful precedent that could protect gun owners everywhere and limit future attempts at restrictive legislation. In the end, the anti-gun movement's high-stakes gamble may cost them everything, reshaping the legal landscape for years to come. In Minnesota, anti-gun city councils are staging political theater, passing unenforceable bans on semi-automatic firearms and magazines. They openly admit these laws are illegal under state preemption, but pass them anyway as symbolic gestures. This isn't governance, it's a taxpayer-funded PR stunt. The real purpose: to pressure lawmakers and create a record of their true goal: outright bans, not common-sense regulation. Their actions reveal the anti-gun movement's intent: prohibition, not safety. When they claim in court to seek reasonable limits, their own legislative records prove otherwise. This paper trail of extremism strengthens the case for constitutional protection. Minnesota's theater exposes the existential threat gun owners face. If given an inch, they'll take a mile, until the Second Amendment is erased. Their disregard for law only makes the constitutional case stronger. The 22 naden sewi, nastid durin, neston samar ardred dem. The Supreme Court Bruin decision changed everything. It established a new test: gun laws must align with America's historical tradition. The old interest-balancing test is gone. Now, only history matters. There's no tradition of limiting magazine capacity. Early firearms prized higher capacity. The anti-gun lobby is scrambling, searching for obscure laws to justify modern bans, but their arguments are falling flat. Even California's Attorney General admits the Bruin standard is too tough for their laws to survive. The Bruin decision is the great clarifier, exposing the anti-gun agenda's lack of constitutional foundation. Now, every ban must stand up to history, and none do. The legal landscape has shifted, and the anti-gun movement is on the defensive. The courts are seeing through the rhetoric, focusing on rights rooted in tradition. The anti-gun movement has proven our point by targeting standard capacity magazines so relentlessly. Their efforts have forced a national conversation about why these magazines matter for self-defense. Every legal argument they make, about what's enough rounds or whether magazines are arms, only highlights their importance. Their political stunts in places like Minnesota reveal their true goal: total prohibition, not moderation. By focusing on these magazines, they admit their effectiveness for lawful self-defense. Their campaign is a backhanded compliment to the utility of these items. They're trying to ban them because they work, because they keep citizens from being easy victims. In trying to erase these magazines, they've made the case for their protection under the Second Amendment. This debate is about more than magazines. It's about your right to self-preservation and the limits of government power. The accidental admission that standard capacity magazines are essential for self-defense is a victory for all Americans. If the courts affirm their protection, it will set a powerful precedent against future attempts to disarm the public. The Second Amendment protects not just firearms but the components that make them effective. The gun control lobby will keep trying, but their overreach has drawn a constitutional line in the sand. As cases move toward the Supreme Court, the principle of common use is now undeniable. They tried to write these magazines out of the Constitution. Instead, they've helped write them in. Soon, this will be a victory for the freedom of all Americans.